Washington State tried to block a public vote on its new income tax. Now the state Supreme Court is stepping in. An emergency petition has been accepted, and within weeks we could have a ruling on whether voters even have the right to challenge this law. This isn't just a policy fight anymore. This is a direct collision between the people and the system that's supposed to represent them.
From Seattle to Los Angeles, this is Left Coast News. No apologies, just the truth.
Welcome back to Left Coast News. This is a major update to the Washington State income tax fight, and now it's officially in the hands of the Washington State Supreme Court. Let's Go Washington has filed an emergency petition after the referendum was blocked, and the court has agreed to review it on an accelerated timeline. Now, on paper, that sounds like a win for voters, but let's be honest about where this is heading. This same court has a long history of siding with government authority over voter initiatives, most notably overturning the $30 car tabs measure, arguing voters were misled on what they were approving. So while this case is being framed as a constitutional review of referendum rights, a lot of people in this state aren't exactly expecting a pro-voter outcome. That's the reality. Still, the stakes here are massive because what the court decides in the coming weeks won't just impact this income tax. It could redefine how much power voters actually have to challenge laws in Washington state going forward. This isn't some slow-moving court case that drags out for a year. This is fast-moving. Let's Go Washington files an emergency petition. The Washington State Supreme Court accepts accelerated review. State response is due by April 14th. The court is set to consider the case at its April 30th NBank conference. And here's the key. They're not just reviewing it, they're deciding whether to force the Secretary of State to follow the referendum process to begin. Meaning, by the end of April, we could know, do voters get a shot at this or not? The signature clock. If the court rules in favor of Let's Go Washington, the clock starts immediately. They would have until June 10th to collect 154,455 valid signatures. That's not a lot of time. That's barely over a month, which is why they're already telling supporters to pre-order petition packets and be ready to move. Because if they win, this turns into a full-scale ground game overnight. And if they lose, the referendum path is dead. The legal fight. This whole case comes down to one question. Did the state correctly block the referendum or abuse the Constitution to do it? Here's the conflict. Washington's Constitution says voters can challenge laws through referendum, except for laws necessary for public safety, public health, or support of state government. Now, the state and Secretary of State Steve Hobbs are relying on decades of court precedent. Specifically a 1961 case, Hope versus Myers, where the court ruled that those exceptions are separate and independent, meaning if a law is declared necessary for the support of state government, it does not need to be an emergency, and it does not need immediate urgency. That interpretation has been reaffirmed multiple times over the years. Let's Go Washington's argument. Let's Go Washington is essentially saying that interpretation is wrong. They argue those clauses were meant to be connected, not separate, meaning you shouldn't be able to block a referendum unless the law is tied to immediate necessity. And here's where their argument hits. This income tax doesn't even take effect until 2028. So how can something be necessary right now if it's not even being implemented for years? That's the pressure point they're putting in front of the court. What this tax actually does. Let's not lose sight of the actual policy here. Senate Bill 6346 creates a 9.9% income tax on earnings over $1 million. It applies to residents and non-residents with Washington-sourced income. It's passed through entities like LLCs and S-Corps. It exempts C-Corps. It includes a $1 million standard deduction. Governor Bob Ferguson called it a historic step to fix Washington's tax system. Opponents call it unconstitutional, economically risky, and now possibly shielded from voters. If they lose, the backup plan. Here's where this gets interesting. If the Supreme Court shuts down the referendum, there's still another path. Initiative to the people, but it's harder. That requires 308,912 signatures, double the referendum, and the deadline is July 2nd. So the fight doesn't end, it just gets more difficult and more expensive. The bigger picture. Step back. Look at what's happening here. A major tax is passed, a referendum is blocked. The court steps in. The outcome will decide whether voters even get a say. This isn't just about taxes anymore. This is about who controls the system and whether the mechanisms designed to check government still function the way the people think they do. The reality check. Now here's the uncomfortable part. Even if Let's Go Washington makes strong arguments, they're going up against decades of precedent, a court that has historically upheld government authority, and a legal interpretation that's been reinforced multiple times. So while this is absolutely a fight worth watching, a lot of people aren't exactly betting on a major reversal here. And if the court upholds the current interpretation, then what just happened becomes the blueprint. Over the next few weeks, everything hinges on what the Washington State Supreme Court decides at the end of April. There are really three possible paths here. Scenario one, the court sides with the state. The court upholds existing precedent going all the way back to Hope versus Myers and agrees that the support of state government clause stands on its own, meaning the referendum stays blocked. Voters don't get a say on this law, and this becomes the new standard going forward. If that happens, this isn't just about this income tax anymore. It effectively gives the legislature a repeatable playbook. Pass a law, label it necessary, shield it from referendum. And once that door is fully open, it doesn't close. Scenario two, the court allows the referendum. If the court breaks from precedent or narrows the interpretation, then everything flips overnight. The referendum is allowed, signature gathering begins immediately, and Let's Go Washington has until June 10th to hit 154,000 signatures. That turns this into a statewide political sprint. You'll see petition drives everywhere, heavy funding pouring in, media coverage ramping up fast, and this lands on the November 2026 ballot. At that point, it's not a court fight anymore, it's a voter fight. In scenario three, the referendum is blocked, and we have to go the initiative path. If the court shuts this down, and that's the expectation for a lot of people, myself included, the fight doesn't end, it just shifts. Let's Go Washington moves to an initiative to the people. 309,000 signatures required. The deadline is July 2nd. That's a heavier lift, but not impossible. They've already qualified multiple initiatives in recent years, so they know how to run that ground game. It just becomes more expensive and more intense. This is one of those moments where the outcome matters, but the precedent matters more. Because if the court confirms that lawmakers can shield laws from referendum using this clause, then the balance of power shifts, not overnight, not dramatically, but quietly, from the voters back towards the legislature. And those are the kinds of changes people don't notice until they try to use the system and realize it doesn't work the way they thought it did. So by the end of April, we're going to have an answer, not just on this tax, but on whether Washington voters still have a real path to challenge laws they don't agree with. And that's what we'll be watching. This is one of those stories that's going to move fast. By the end of April, the Washington State Supreme Court is expected to weigh in, and that decision is going to determine whether this income tax fight goes to the voters or gets shut down in the courts. Either way, this doesn't end here. If the referendum is blocked, the fight shifts to an initiative. If it's allowed, the race for signatures begins immediately. But the bigger issue remains the same. Who actually has the final say in Washington State? The legislature or the people? We'll be tracking this every step of the way. Thank you for watching Left Coast News. Please like, share, and follow us if you got anything out of this story. You can find us on YouTube, Rumble, Brighteon, BitChute, and Patreon. You can follow us on social media: Facebook, X, Truth Social, Instagram, LinkedIn, and TikTok. Also, drop a comment below and let me know where you think this is going. If the court upholds this, should lawmakers be able to block a public vote just by labeling a law necessary? Thanks for watching.